You know, Sandy, the last time I was at a zoning board of adjustment meeting was when they were appealing a decision about the wing store.
I heard you say that earlier.
It was not a friendly meeting. They were ready to car in front of me, and Olin looked on the door. He was just signing vote in my favor. Okay, that's fine.
Folks, your mics are probably on mute, so if you just press the button once, we got to share a little bit because we're waiting on some parts.
Supply chain.
Harder, Carol. Tell you what, I'm going to turn it so I can see him. How's that? If anything goes wrong, I can fix it. All right.
You can fix anything. Sure, we can do that.
All right. Rolling, you're rolling.
Okay. Okay, I'm Olin Finch, and I'm calling this meeting for the Board of Adjustments to review a variance. And today we have Robert Hobbs here, and I'm going to ask him to give us an overview of the procedures.
Okay. Thank you, Mr. Chairman. At this time, we will now open the quasi-judicial hearing. When considering an application for a variance, the Board of Adjustment sits as a quasi-judicial body. A quasi-judicial hearing is the process for the board to adjudicate how general law applies to a particular situation based on an evidentiary record presented during the hearing. Your two key responsibilities are first to determine contested facts, and secondly, to apply legal standards to the facts. You may apply only the standards contained in the statute. You are not permitted to change or modify these standards during the hearing or as part of your decision in this case. In conducting this hearing, certain safeguards must be instituted in order to give the applicant a fair hearing. The applicant has the right to cross-examine witnesses and offer rebuttal evidence. The board members may ask any witness at any time, a question of any witness at any time during the hearing. Questions from the floor will not be permitted except by cross-examination from any of the sworn witnesses once recognized to speak. A member must not vote on the application if the outcome of the matter being considered is reasonably likely to have a direct and substantial financial impact on the member. If such a direct and substantial financial conflict exists, the member should disclose it and ask to be excused from consideration of the matter. If any of the members present have had any contact with anyone prior to the hearing in which the particulars of the application were discussed, or if you have received letters, emails, phone calls, or contact from anyone concerning this matter prior to the hearing, please remember that you must disclose these communications. You must base your decision on this application entirely on the facts presented during this hearing and disregard the particulars discussed with the applicant or another party prior to the hearing. A member must base his or her decision on the evidence presented during this hearing. Any member who has developed a predetermined opinion or bias on the outcome of the application before the hearing must not participate in the decision on this application. Your decision must be based on competent, substantial, and material evidence presented and properly entered into the record of this hearing. Crucial facts used to determine the outcome of this hearing must be based on sworn statements made by witnesses during this hearing. You may be presented before or during this hearing with copies of unsworn statements contained in letters, emails, and the like. You may also be presented with an affidavit without the person giving the affidavit being present at the hearing to be questioned about the content of the affidavit. Such unsworn evidence is not competent or substantial evidence and can only be used to corroborate or supplement other sworn evidence presented during the hearing. Unsworn evidence can never be used as the sole basis for your decision. At this time, if any member needs to recuse themselves from the hearing for one of the reasons that I've explained, please request that a motion be made for you to be recused from participating in the hearing or voting on this matter, and if you'll do so at this time. Okay. Seeing none, then at this time, if any member needs to disclose a communication about the subject of the hearing that the member has had with one or more, with the applicant or another person prior to the hearing, now's the opportunity for you to disclose that communication.
We're good.
Okay. At this time, the member of the town staff will swear in the applicant and all witnesses who plan to provide testimony or evidence in this case. And if you plan to speak or you think you might want to speak at this hearing, please stand to be sworn.
Everyone put their hand on the Bible.
Talk about timing.
Yeah. Raise your right hand. After I give the oath, say, I will or I swear. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
I do. I swear.
Thank you.
Mr. Chair, I will proceed. The staff, I'll ask staff to proceed with the evidence unless you have anything further to comment on at this point.
No, please proceed.
Okay, thank you. This time, Donna Creef will make a presentation on behalf of the town staff.
Good afternoon. My name is Donna Creef, and I'm working in the absence of Joe Hurd. And so I'm going to go through my staff comments. I believe that you guys have all received a copy of this. Included with my staff comments are several exhibits, which will be entered into the record as the staff exhibits. Those are exhibits A through F. And Sandy is going to be showing those up on the big screen here. And if you have any questions about those, is that on, Sandy? If you have any questions about those exhibits, feel free to interrupt me as I go through. Some of this may be redundant, but it's important that we get some of the stuff into the record, and so I'm just going to go through my staff comments. There are three particular sections of the zoning ordinance that are applicable today. Those are Section 156.03, which is the RS1 rear yard setback of 25 feet, Section 156.073, parent F of the nonconforming structures section, which deals with the 50% threshold for repairs and maintenance, and then Section 156.167, which establishes the variance criteria that have to be met in order to issue the variance. The staff information details those exhibits. The property in question is lot 125 of the Four Seasons subdivision. And there is attachment C, and there's the plat for Four Seasons, which was recorded back in 2001. The address of the property is 1170 Duck Road. And on the plat, you'll notice that at the time of the recordation in 2001, the lot size was 21,965 square feet. The survey that was used, that's included in the packet, and that was used at the time of the permits for the pool repairs, indicates this lot area to be 12,615 square feet. I'm sorry. The improvements at the subject property were completed in 2008. The pool was constructed at the same time as the house that is on the property. There is a copy of the tax parcel card included in the packet, which is marked as Exhibit B. One of the important features that is applicable to this variance when you look at the plat for Four Seasons is that there is a 50-foot wide vegetated buffer that runs along the front of those lots. And it just so happens in my other life, I was the planning director for Dare County, and at the time the plat was recorded, I was the staff person that did that plat. And I just think this is ironic that I'm standing up here talking about this after all those years. But anyway, that vegetative buffer was required at the time of the plat because establish vegetation for the protection and quiet enjoyment of the property owners there, as well as to vegetate the lots from the road. The vegetative buffer results in a 55-foot setback, which is more than the typical setback of 25 feet, which is established for the RS1. The applicant is seeking a variance from the rear yard setback of the RS1 zoning district, which establishes a 25-foot setback. The property has been subject to substantial erosion over the course of several years. The improvements on the lot are in their original location as they were in 2008. So the house and the pool improvements are in the same location, but the land has subsided due to erosion. There's been a couple of significant storm events that resulted in erosion in addition to the normal erosion that occurs on the sound side there. They were granted a special exception permit, special exception 2020-005 by the board to do some repair work there to the pool surround, the reconstruction of open decking, stormwater improvements, retaining walls, and vegetations. That was submitted, that was approved in September of 2021. And then in January of 2022, they got a second permit for repairs to the pool. The intent at that time was to add pilings underneath the pool and to replace the pool barrier. Subsequent to the issuance of that building permit, the pool was removed. The applicant has indicated in his application that the pool was unsafe. And so in the planning world and the building inspection world, the 50% threshold is a standard threshold that is used. Typically anything that's 50% or less is considered to be repairs. If it's more than that, it's considered to be something else. It's considered to be more than repairs and maintenance, and it's treated differently. And the zoning ordinance, the Duck zoning ordinance, references that and discusses that in section 106.073F. And it talks about pools and accessory structures can be permitted and contrary to your established setbacks if it's considered a 50% threshold and if it's repairs and maintenance. So there are 4 conditions that are outlined in the zoning ordinance that have to be met in order to issue the variance, and I have outlined those 4 criteria. I'll be glad to go through those really quickly. The first one is the unnecessary hardships would result from the strict application of the ordinance. Again, I've touched on the erosion that has affected the property and that has rendered the lot to be non-conforming, and that compliance with the 25-foot rear yard setback would be difficult. The second criteria is the hardship results from conditions that are peculiar to the property, such as location, size, or topography, hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public may not be the basis for granting a variance. And, the existing dwelling and the erosion is something that has resulted in the request for the variance. It's not anything that's a financial hardship or a personal hardship from the applicant, and they are unique to the property. The erosion is unique to the property, and then the fact that there's that 50-foot setback in the front there is requiring them to have a different front yard setback or a setback that's in excess of the 25-foot front yard setback. So when you have the erosion and then you have that vegetative buffer and the fact it's compressing the property there in the way that they can locate the structures on the property. The third criteria is the hardship did not result from any actions taken by the applicant or the property owner. They did not, they purchased the property in 2012. And they have not contributed to any of the circumstances there that are the request for the variance. And the last is the requested variance is consistent with the spirit, purpose, and intent of the regulation such that the public safety is secured and substantial justice is achieved. The applicant has indicated that the pool, when he went out there to do the work, that it was unsafe and that it needed to be pulled out and not just repaired. And I'm sure that the applicant will address that in more detail than what I have, or the attorney for the applicant. There has been a CAMA permit secured for the work, and so the fact that there is that section in the zoning ordinance 156.073F that talks about the non-conforming aspects of accessory use structures, it's as if the ordinance anticipates these situations like this, and it's giving that flexibility where it's recognizing that. So it is the staff's opinion that it is appropriate for the board to act to allow for the granting of a variance and the replacement of the pool at a reduced setback and beyond the 50% threshold. And I'm going to sit down right there unless you guys have any questions of me.
Does anybody have any questions for Donna?
No.
Thank you, Donna.
Does the applicant have any questions for Donna at this point? No. Okay, thank you.
Yeah, just an observation. I read through all this quite closely. This property from the original surveys lost.
I'm sorry, is this a question?
It's observation.
Well, I think we can reserve sort of comments or discussion of the application to the deliberation section.
I have, the question is, when was the barrier wall built? Because it has ones now.
The bulkhead wall, is that what you're referring to as the barrier wall? I would assume, and Sandy may be able to answer this better than I can, but I would assume that there was some sort of bulkhead that was established at the time the house was constructed in 2008. No.
Well, I think we'll get that.
Yeah, if you want to come up, do you have a?
That's it. Yeah, we're happy to address that during our presentation as well. Okay.
Can you wait for their presentation to have that question answered?
Okay, so the applicant would like to address.
Good afternoon, Chairman Finch and members of the Board of Adjustment. My name is Clint Cogburn. I'm an attorney with the law firm Ward & Smith. I'm here this afternoon on behalf of the applicant, which is Evolve Design and Build LLC, which submitted the application on behalf of the property owners John and Kristen Replogle. Our team here this evening consists of John and Kristen, the property owners. During our presentation, you'll hear from John, and he'll provide some of the information and answer questions that you may have about the property background and can give you some more detail related to the property. He'll also provide some factual background as to what led us here today, what led us to the variance request. You'll also hear from Mr. Jordan Danaker, who's the owner and designer of Evolve Design and Build. Jordan will testify to the timeline of events concerning the pool at issue, the attempt to repair the pool, the structural defects discovered during that repair process that resulted in the need to replace it for safety reasons, and also the changing setbacks at the site that staff has already mentioned, in which I'll do a quick run through of GIS imagery here shortly. Finally, you'll hear from Mr. Clark Twitty. Clark is the president of Twitty and Company Realtors, and he'll provide testimony about the negative impact to the rental value of the property and the average rental rates if the variance is not granted and the pool not replaced. Clark will also speak to the impact on the real estate and the resale value of the property if the variance is not granted. I'll kind of be the master of ceremonies on our end. I'll, at the conclusion of our presentation, come back and tie all of the testimony to the 4 factors that staff just ran through. And I'm also happy to answer any questions at the end of our presentation. As staff noted, we're seeking a 19.14 foot variance to the rear setback requirement. This will permit a rear setback at the property of 5.86 feet, which will allow for the replacement of the existing pool and will avoid the substantial expense and loss of rental value of the property for my clients if they were forced to tear out the pool and fill it in. The property here, as staff outlined, and actually we have a binder that all of you should have. I know that some are sharing it. We will run through some of that. A lot of it is what staff has already gone through There is an index on the front of that if you have any interest in what the documents are, but we will run through those, or at least run through the information in those tabbed documents during the presentation. And if you have questions concerning that as they come up, please do not hesitate to ask any member of our team those questions. As staff mentioned, the property here is 1170 Duck Road.
Mr. Cochran, on your binder, are you now submitting that into, are you going to do that individually?
So I was going to do it collectively at the end after people have provided the testimony related to those documents. I think that's probably the easier way to do it, if that's fine. Okay.
Just as long as it comes in, that's fine.
Yeah, I will make sure to do that at the conclusion of our testimony. But yeah, the address here is 1170 Duck Road. If you look on GIS, and we have some of the GIS imagery here for you just as reference, and I know staff has mentioned this as well. If you look at it, this property is flanked by two other residential properties with similar pools and pool locations. And as staff mentioned, one of the issues that John and Jordan can talk to, I'll mention briefly, but one of the reasons we're here is just because of the substantial erosion impacts that have really taken a toll on this property. Here we have an image back in 2012, or at least the GIS image from 2012. That's in 2016. And now that's the most recently available GIS image for this property in 2020. So you can just see the progression of the erosion, the loss of setback. As staff mentioned, this was previously compliant, but due to the erosion, that's why we're here today. And so we'll be able to go into more of that in detail. I'll now turn it over to John. He will speak to you again on the timeline of events here, be able to provide some information on the property and answer any questions you have related to that.
Good afternoon. I'm John Replogle. Along with Kristen, we are the owners of 1170 Duck Road. I've been a property owner here in the Outer Banks for 36 years, and we currently live in Raleigh, North Carolina. The primary use of the home is for rent. And to address a prior question, the original bulkhead was built by the developer. The bulkhead was installed before any of the lots were sold by Four Seasons Realty, or Four Seasons Development, I guess was the name of the company. Over the last 27 months, we have really tried to address, in compliance and in consultation with the town, significant issues of rainwater and soil erosion. And so we started this process in January of 2020. We hired house engineering to do soil tests, to examine the bulkheads, to come up with different designs that would allow us to repair the back area while remediating the extensive rainwater issues we were facing, as well as the underlying soil erosion. The property at the time of construction was not well compacted. It is loose sand. And the weight, literally, of the house and the pool deck have been heavy. And so we've actually had work done to the physical structure of the house as well to support it over time. And we want to address this as a long-term issue, not only for the property and the safety of the rental guests, but also to remediate the extensive runoff into the sound. So we started that journey in January 2020 with house engineering and with Bernie Mancuso, who was the builder of the house. Over 9 months, we did extensive work. And in October 2020, we applied with the town for a special use and exception permit. 3 months later, we were granted that. And I came here, this is my third time appearing on this matter in front of the town of Duck. I appeared here to make the case for why this was the right way to move forward. We had great deliberation. We took input from the board. We actually changed our designs and our plans resubmitted, and ultimately then had that approved to go onto the town, which that special exception was granted in February 3rd of 2021, just over a year ago.
Excuse me, when you're making reference to the board, are you speaking of the Board of Adjustment, the board?
You know, I'll ask Sandy for the right nomenclature. She's been here for all that. I'm sorry. I don't have all the names.
Presentation to the planning board and town council. So the special exception was approved by town council.
Thank you, Sandy. And so that was finally approved, and then we were not approved by CAMA. So that we had to work with CAMA to reach a settlement. That took another 6 months. We finally did reach a settlement with CAMA. We were granted permission to go, and we started the work then. We were scheduled to start the work in October of last year, and at which point our builder walked away from the project, he and his contractor, claiming they were too busy. So we did engage Jordan Danaker, who will speak. He's with Evolve Design. They finally were able to start the work in early this year, in January, and did some of the demolition, and then we're beginning the pool renovations, and that's when the pool fell apart from faulty building. So here we are, 27 months of time, 3 visits with the town, engineering designs, hours and hours of consultation, attorney time, and I'm hopeful that third time's a charm.
Questions from the board
No questions.
or from staff?
Thank you.
Thank you.
You'll now hear from Mr. Jordan Danaker, who is the owner of Evolve Design and Build, and has been, as John mentioned, engaged on this project related to the initial pool renovation, and now what has unfortunately become a pool replacement. But he'll be able to speak to you on that process, about the original building and development permit that was issued for the repair, the discovered issues with the pool, and why those created a significant safety issue that led to the need for this request and for a replacement.
Hey, good afternoon. Jordan Danaker. I'm from the mainland, Currituck over there. So anyway, just talking back on John's timeline, he kind of explained everything that was going on, but I think there was a little bit of confusion on the initial builder of the pool, which was Waterworks, versus us. We were actually hired initially to do the hardscape, and they had a pool contractor and building contractor lined up to do the refurbishment to the pool. So we are a hardscape contractor, although we do pool installation as well, although at the time they had a contractor aligned that had worked on the pool initially. So once that contractor had decided at the time that this was no longer the project for him, we were the ones to step up to the plate. We had the most background and had designed the initial plan. We were just taking over the rehabilitation of the pool and trying to get it in the proper safety standards and condition where the project was a success all around, taking into account for all of the life safety hazards. So when we went to demo the pool, and back when we were contracted to do the pool portion, we were just contracted to remove the pool floor. It was a pretty simple procedure. We were going to cut in, remove the pool floor, put the supporting pylons under it. Because of the weight of the water and the weight of the pool, it was going to be meant to support that structure so that it could no longer erode down the hillside, much like bridge pylons, okay? Basically, upon cutting on the pool and starting demolition with the pool, the simplest way to put it is it crumbled apart. There's standards and codes that North Carolina does to regulate swimming pools. However, North Carolina code does not recognize what is an acceptable practice for the cage in a concrete pool, which is the rebar. So when we started to demo the actual pool, we found that it was comprised mainly of number 3 rebar and inadequate thickness of concrete. So industry standards and best practices adapt to number 4 and 5 rebar in all footers and walls. Number 3, which was used in the pool, is typically seen in driveways and what we call pedestrian applications, your standard residential 4-inch thick applications, where a pool is supposed to be 7 inches in industry standards. So essentially it just fell apart like spaghetti noodles. It wasn't enough rebar or concrete to hold the structure together. It wasn't necessarily that we moved quickly or tried to, create more room for the project. It just essentially fell apart around us, which is the need to have to remove it all. And the biggest concern, aside from the construction, is there's a process when you have a cage around a pool, that rebar structure, that creates proper bonding so that nobody gets shocked. Things have to be bonded and grounded to the equipment, and unlike fiberglass pools and liner pools, concrete pools are especially critical because of the amount of rebar and steel. Somebody can have an electrocution, okay? The cage never had proper bonding and lugs around it, or it was lost sometime in the rehabilitation process prior to us arriving. As me as a father and, also worried about the staff, we wouldn't want to put anything back together that somebody could get hurt, somebody's kids or anything like that. So we made the decision to remove it and seek the variance so we could put it back properly so that life safety wasn't a concern. The construction was poor, but overall the safety was the biggest concern. So that's what has led us to request the variance today. And that's basically the backstory on the pool. But I know John and Kristen have been working on this project as a whole to kind of take care of all of the, requests that the town has made in regards to the CAMA, switching the hardscapes to slatted decking. And I know they're committed to making sure that the property is safe and sound and doing it correctly. So that's why they're requesting the variance, to make sure things are compliant. Questions for me?
No.
All right, thank you.
And just as a housekeeping, and I'll move these into evidence at the end of our presentation, but of tab 4 of our notebook is the order granting the special exception that John spoke to. Tab 5 is the building and development permit that Jordan just referenced related to what the initial repair was going to be. Number 6 are pictures of the damage that was discovered that Jordan just referenced. And now tab 7 is related to our the next speaker, who is Clark Twitty. He's going to speak to the impact of the rental value and property value. He'll provide some more of his credentials as well in this space, and he'll be able to answer any questions you have there.
Hello, everybody. Good afternoon. Chairman Finch. It is a great opportunity to join you this afternoon. Thank you for allowing me to come share some of my thinking with you. We'll share 2 buckets of ideas. Number 1, what we know about value in the market. Number 2, what we think about value in the market. You'll see in one of your attachments, tab number 7, what we think the market reaction would be to the loss of a benefit or a feature to any home. Part of our job is to help homeowners optimize revenue. The loss of a pool, which is enormously important as the market makes a decision to select a rental property, is enormously important in terms of value and future outcome, and I'll divide those 2. Value, looking backward into hundreds of thousands of data sets, we believe that the loss of a pool is about 10% of the value of a home. The value of a home we measure in 2 ways. Number 1 is annually recurring revenue. That's the money that a home generates on an annual basis. Number 2 is resale price, what a home will sell for at some point in the future. Now, since the dawn of time up until the past several years, the number to think about there has been 10 times. The price of a home is usually very closely related to 10 times the annually recurring revenue, the gross revenue the home generates. In this real estate market, that multiple's gotten even bigger. Now, what does all that mean? We believe the loss of a pool decreases the market's demand, the market's desire, what it's willing to pay for that home, not only on an annual basis, at least 10%, but as we fast forward into a potential sale, 10 times that. So as a round number, if the house rents for $10,000 less per year, it will sell for $100,000 less over time. That's a little bit about value. Number 3, let's talk about the regulatory law that supports the professional property management world. General statute in North Carolina, 42A, the Vacation Rental Act, says that in the event a home's material condition is altered, any professional manager has the responsibility to go back out to anyone who has made a travel plan, a reservation in that home, and notify them of that change. The Vacation Rental Act stipulates that a pool is a material fact in the selection of that home. Translated, that means that any guest, when they are notified of a loss of a pool, could ask for a full refund. We would be obliged to give them the full refund, and then we can put the home back on the market. But because of the way rental homes rent, which is to say significantly in advance, the probability of a much lower rental number begins to increase. And that's what I mean when we think about what we know and what we think about future financial outcomes. In summary, we think a pool is very valuable, not only in an annual basis, as you'll see in your tab, but also in a potential resale. I welcome your questions, and let me know if I've bored anybody to tears or I've talked too long.
Mr. Cogburn, do you want to provide or assist with providing credentials for your witness as far as...
I'll let him. He can speak to those, and then I'll happily, after he discusses his credentials.
Just to get those on the record, I think would be...
Sure. So my name is Clark Twitty. I work across the street at Twitty & Company. We've been doing business in downtown Duck for almost 45 years. We welcome hundreds of thousands of guests annually to the Outer Banks. I also happen to be the chairman of North Carolina's Vacation Rental Management Association as a whole across the state, and I'm also fortunate to be the chairman right now of the Outer Banks Community Foundation.
Any questions from the board or from staff?
Thank you, Clark.
Thank you for your time this afternoon. On a personal note, Donna, before you retire, thank you for your service to Dare County.
Thank you.
Before you retire again.
So now to kind of tie this all together, I'll run through the variance requirements, the standards and burdens that we are obligated to carry, and explain and kind of bring everything together that you just heard to demonstrate that we clear each of those required standards. As staff mentioned, the town sets forth the requirements for an issue, or sets forth the requirements to issue a variance in section 156.167 of the UDO. These are consistent with the same standards that are found in North Carolina statute. Per that section, a variance should be granted when unnecessary hardship would result from carrying out the strict letter of the UDO. The 4 prongs that staff outlined earlier are unnecessary hardship, conditions peculiar to the property, that the issue is not caused by the property owner, and that the requested variance is consistent with the spirit, purpose, and intent of the UDO. I'll go over each of those briefly right now. The first one is unnecessary hardship. And here, unnecessary hardship would result from the strict application of the ordinance. As Mr. Twitty just detailed in his testimony, strict application of the UDO would result in the loss of the pool for the property. The economic impact to my clients would be significant, both in lost rental value and to impact to potential future resale values. Concerning conditions peculiar to the property, the violation here exists because of the changing setback that staff detailed, as well as shown in these GIS pictures, due to erosion and just natural causes. And as staff indicated, that erosion over the years has caused a substantial loss of setback and of rear setback in this case, and that the normal water line and property line there has changed significantly. The violation also exists, as Mr. Daniker detailed, due to the unique issues discovered only after a permit to repair the pool had been received and during the process to actually repair the pool. On the third prong of not being caused by the property owners, as we just detailed, John and Kristen are not responsible for this. This is a mix of the impacts of erosion and as well as just the unfortunate discovery of some less than exceptional pool craftsmanship. And so they should not be held, they should not suffer because of that, because their actions did not result in the need to seek the variance here this afternoon. The final prong is that the request is consistent with the spirit, purpose, and intent of the UDO. Here, the request really balances public safety. It seeks to put together a better pool, a safer pool, and it also it's also worth noting here that my clients attempted to fully comply with the town's code and procedures in repairing the pool rather than replacing the pool. We're here as a last resort. This was not the first thing they sought. This is literally a last resort request here. Additionally, I will note in tab 8 that we would submit this is consistent. If you look at the board's own November minutes, the board recently approved a very similar variance in terms of scope. And so we would think that that would weigh heavily concerning the fourth prong of consistency with the spirit and UDO. And that's also precedent that the board has set in these types of matters. Some additional requirements that the UDO sets forth are that the requested variance is the minimum possible for reasonable use. Here, given the layout of the parcel as you see on these GIS images and the existing structure, this is really the only logical location for the pool. It's not like we can put it somewhere else. This is, we're pretty much limited to this space. Additionally, the proposed location of the new pool will be in the exact same place as the current pool and to the exact same dimensions. We're not asking for a bigger pool. We're not asking for more than we already have. We're just wanting to get a variance so that we can put in a safe pool that will look identical to what has previously been there. The second additional requirement that's laid out in the UDO is harmony with the UDO. What I will submit to the board is variances provide a way for the board to properly balance undue hardships against appropriate enforcement of the UDO. Here we're really balancing the equities. As we would submit, the impact here is minimal, if non-existent, again, given that we're putting the pool in the exact same location to the exact same dimensions and are only here out of necessity and after an attempt to repair the pool as a non-conforming legal use. And that the impact to my clients compared to that minimal or non-existent departure from the UDO would be extreme and significant, as you've heard, specifically from Mr. Twitty. Additionally, we would submit that there really is no negative impact to the surrounding community or to neighboring properties, again, just given what the request here is, and that the pool, again, will be in the exact same location and to the exact same dimensions. It's not going to impede on anybody's use of their property or be unsightly or result in any negative impact to adjoining properties. So that is why we're here. We would submit, again, that this request is precisely why variances are permitted by state statute and by the town's own ordinance. A minor violation of the setback here as a result of changing physical aspects and prior pool work, neither of which is the fault of my clients. And because of that, we asked the board to weigh that minor departure from the UDO related to the rear setback against the significant cost and burden that would result from the strict application of the setback. I'm happy to answer any questions. I will now move that our exhibits, which are applicants' exhibits 1 through 8 in your binder, I would ask that those be admitted into evidence and made a part of the record. I'm also happy to answer any questions and would also reserve the right to provide rebuttal testimony following any additional speakers.
I have something to say. First of all, I think everything is very clear, and I commend the applicant for his patience. I can't imagine taking that much time to get something done. I think this question has to be asked, and I don't know who's the best answerer, Evolve or, I don't know, or the real estate. You're replacing the pool exactly as it existed. What about making a smaller pool? I mean, I think that question has to be asked. Has that been considered? Would that make a difference?
I will defer to Jordan. What I would say is that my understanding, and Jordan can speak to it, is that
No matter what, they're going to be
the issue with the pool wasn't the size of the pool. It was just with, again, the rebar that was used in supporting it, and that the proposed new pool will be fully compliant, safe, will have all of the requirements, meet code, et cetera. And so it was, to my understanding, it's not considered. I don't think that they should be required to build a smaller pool if they can build a safe and compliant pool to those same dimensions. I don't know if that answers your question. I'm happy to have him come up as well.
Well, I think the size of the pool would determine the amount of setback. Or
Potentially. I think what you're looking at, though, is a fairly minor variation there. We would still be asking for a variance if it was a smaller pool, given the nature of the setback. The request would still exist.
I just thought it was a question that had to be asked. Thank you.
No, and we appreciate that question. Thank you.
Well, how wide is the pool right now? Was it 14, 18, east to west?
I can't see.
But there's all these other improvements that are.
Right now, the pool's actually 14 by 22. And just to speak on the size of the pool, I think the important thing to recognize is the stormwater plan was drafted on the current conditions. We spent a lot of time revising that stormwater plan so that it adhered with the county, or excuse me, the township. So I think by amending the pool size, we would then have to look at the retaining walls, which would change the scope of the stormwater plan, which we know is right now the stormwater plan works, and we spent a lot of time engineering. So I think the important part is that we stick with the same concept. We don't change anything. We developed a stormwater plan that is consistent with the town standards and complies with it. So that would be my biggest argument against the size of the pool.
Well, I think, so Carol will understand, I mean, if the pool's only 14 wide and you're asking for a 19-foot difference in the setback, so it'd be impossible to make it narrower. It'd be totally gone away to try to get, if you're implying you could make it small enough to go into 25 foot, it's never going to happen.
And that's fine, and I appreciate your answer. Thank you.
Oh, yes, ma'am. Mm-hmm. Have any other questions for me?
No, I'm good.
Okay.
Anybody else?
Yeah.
Thank you.
Thank you.
Probably.
Are there any other witnesses who'd like to make a presentation? I'm sorry, come forward if you're going to.
Well, I'm here for the public comments.
Well, on this hearing or on something else? Yeah, well, this will be the time. Have you been sworn already?
Yes.
Okay. If you'll come to the podium and state your name and address, please.
Hi, Bob Webb. I own the property at 1166 Duck Road, but my permanent residence is 9315 Navajo Drive, Brentwood, Tennessee. Too long a drive from here, but that's besides the point. I want to speak in favor of the variance, of them being allowed to put their pool back in. But I also have some background I'd like to go through. We removed our pool at 1166 because we would not be allowed to replace it. We wound up buying the lot between us and 1162 so that we could place our pool out of the CAMA zone, way out of the setback. It's 50 feet now. And 1162 did the same thing because their pool was failing. I think that the board needs to realize that what you're approving today is also going to apply to, if you look at the map, 1168 is below 1170, and 1172 is above. And both of their pools are failing, and they have essentially the same circumstances. And I think if you allow 1170 to do it, which I think you should, I think you also need to proactively talk to 1168 and 1172. 1172 made extensive repairs on their pool, I'm going to say about 5 years ago. Sandy would know better than me. I think it was right around the same time as the riprap that they put in. And 1168's pool is failing. It's across the driveway from us. I know that's kind of beyond the scope of this meeting, but I don't think you can make this decision independent of other decisions that are going to come your way probably very shortly because of this. Also, I have some questions about the staff report. Is that something I can ask at this point, or?
Yes.
Okay.
Well, first of all, let's ask if there are any questions about what you've already said. Does the board, staff, or applicant have any questions for the witness? Okay. Proceed, please.
Okay. In the staff report, it does say that there's really no similarly situated homes to 1170. I think that their attorney has already made the point that there are similarly situated homes where the pools were built way too close to the sound, and also the elevation is too high. I mean, that was the situation that we had with our house. We wouldn't have bought the lot if we'd been allowed to put the pool back where it was. And through the permit process, we were told we could, but then later on we were told we couldn't. So we bought a lot that we didn't want to buy, but that was pretty much the choice that we were offered. Also in the staff report, it says that the property was bought in 2012, the 1170 house. Looking online at the property records, it was bought in 2008, and it was moved into an LLC in 2012. I think the applicants are the original homeowner. I don't know. I haven't asked them that question. And then the last thing is that I failed to mention I'm on the Four Seasons board. I'm not here representing the board. I'm here representing myself. The vegetation easement or buffer in front of the house can be entered into. We did it when we moved our house, which I don't recommend to anybody doing that. But not that it would be a great option, but you can put a pool in that vegetation buffer. And Four Seasons has to waive that. But they waived it for our house. I assume they would waive it for a pool. So that's it. Thank you.
Go ahead.
I'm not sure if there was a question in all that, or if that was just comments. I mean, you said you had a question about the staff report, and I'm not sure what the exact question was. Is when I looked at the tax records, I didn't pick up on the fact that it was an LLC, and a lot of information was...
I'm not a tax attorney.
Right.
I'm not an accountant. But looking at the records, it went from being owned by the applicants to going into the LLC, and there were no taxes paid. So if there's no taxes paid, it's not a real estate transaction. So my point is that you can say that they're, I think they built the house. I could ask them the question if you'd like me to, but I don't think that's my issue. So I'm just, look, you could have told me I was wrong.
And I'm at a loss here because I haven't been involved in the permit processing at all up to this point. I will tell you that the buffer there, if Four Seasons grants the buffer, then that's a separate action than what the board is here considering tonight, and that has no bearing on what they're doing. They have to act on the application that they've received.
It does have a bearing on where the pool can go, and I'm just presenting that there are other options for the pool. So.
And that's their prerogative. They may, if this is turned down, I'm sure they're going to pursue that, but that's where we are tonight.
But I started off by saying I think they should be allowed to replace their pool. I'm just asking questions now about the staff report because, my understanding is different than what was in the staff report. I don't know if I'm right. I don't know if I'm wrong. But the bottom line is I'm still saying
I don't know.
that they should be allowed to replace the pool, just like we should have been allowed, and 1168 and 1172 should be allowed. I mean, the biggest issue is here, what do you do going forward? I mean, I think you need to understand that those pools need to be replaced too, and I don't really appreciate that you're essentially laughing at me about this.
I'm not. I'm at a loss here because Mr. Hurd is the full-time planning director, and I'm just filling in for him, and I'm going by the staff notes. And I agree with you. There is going to be an issue with the lots on either side of this, and they're going to have to address that. And is it appropriate to do so through a variance? I would tell you from my perspective, no, because, and Mr. Hobbs can speak on this, but variances aren't to be used as precedents. And so it may be that in the wisdom of the board tonight that they instruct the town to study the issue and all, but I think that what the board has heard tonight through testimony is that there are peculiar circumstances there that go back to the construction of the pool, and in that they were able to secure a CAMA permit. I don't know what your process was with the CAMA permit, but I think them securing the CAMA permit was...
I'm intentionally avoiding my process because my process was 4 years. So.
Right. So, I've been called in to pinch hit here, and so I don't know how to adequately respond.
And I appreciate that.
Yeah.
But I think sometimes variances do set precedent, and I'm just saying I think this is one of them. So.
Do you have any other testimony?
No, I'm willing to walk away from the mic now.
Are there questions from staff for the board or from the applicant on this testimony? Okay, thank you.
Thank you.
Are there other witnesses who would like to speak? Or, yes, sir.
And I'll keep it brief just to respond to those comments. One, we appreciate his support of the request, and I'm glad that he is supporting the request that we put before you. In terms of the concern about this being a domino effect, I don't know what the status of those pools are for the properties above or below our subject site. If they do fail and have similar circumstances to us, I'm sure that they can and will likely submit requests here, and the board can weigh those factors at that time. The board certainly does not, and frankly should not, consider that in its review of these facts. This is a fact-specific inquiry for the factual circumstances that we put before you related to this specific property, and that's what variances are for. It is not to try to forecast or tell the future on what may come before the board at a certain date, and also not knowing the circumstances of either of those pieces of property. And so we would encourage you to look at the facts and the testimony that we presented relative to the property related to this specific request and weigh that in making your decision here this afternoon.
Any final questions from staff or from the board or from any sworn witness about the testimony or anything relating to this application?
No, if there's none from us, and if there's none other from the audience or from the participants, I guess we can enter into our discussion.
Okay, and so at this point, I'll remind, first of all, we'll close the public hearing. We have two alternates who will not participate in the deliberation or voting of on this matter. The vote of a 4/5 majority, that is 4 of you, is required to approve the application. The staff has provided a draft order in your agenda package. If a board member wants to make a motion is receptive to adopting the draft order provided by the staff, you have the option, if you wish, to approve the order and adopt those findings and conclusions as the action of the board. Or if you prefer, you can have individual votes on the separately on the 4 findings that are set forth, that have been set forth in the evidence and also in the draft order. So I'll turn it over to the board, and you can decide which way you'd like to proceed after your deliberation.
Okay, well, we have 2 choices. We can deliberate and discuss each of the 4, or we can just accept it as it was drafted. And I guess before...
And by doing that, you would adopt the findings and the conclusions in the draft order from staff, which would be all 4 findings and the conclusions.
Right.
And also the approval of the variance upon adoption of all those findings and conclusions.
Correct. And before I ask the individual board members who has comments or motions, just briefly, I guess I want to confer with you that obviously we're here to review a variance, and obviously variances can be precedents for other variances, but we're not here for a text amendment. We don't have the status to change the town codes or in any way. So all we can do is judge on the variance as presented.
Well, even in that case, I mean, I think that there's a very good argument that the board has not been presented with substantial and competent evidence of anything besides the one property that's before you today. And so I would advise you as your attorney that you should not consider any evidence relating to properties outside specifically their specific situations unless you've received competent and substantial evidence about that.
Correct. So, speaking to the other board members, is there anybody that would make any comments first or have questions?
Look at this piece of property. It's lost 43% of its land since the original survey. It's lost more than 20 feet of shoreline. And thank God, whoever decided to put up the seawall made a great decision, because if they hadn't done that, they'd have lost more already. The sound would probably be up to the pilings of the house. I think this is a reasonable request. And I think we're supporting the pool with pilings. It's not going to do any damage to the rest of the property. But I think that's critical to put a pool in, and the weight of all that water, it needs to be on its own pilings. So I propose we accept it.
Chairman, I find this to be really a classic case of all the training we've had. We've had the separate training for the Board of Adjustment, what meets the criteria and everything. And I think it's a classic case that's well presented, that it's definitely a variance is needed and should be approved.
Does anyone have anything to the contrary to say? Before
I
we
did
get-
not. I thought the staff work was great.
Okay. Would anybody like to make a motion?
I'll make a motion, we accept the proposal.
Ed, can you speak into the mic, please?
I'll make a motion, we accept the proposal as written.
So that motion will be that you're going to basically adopt the four findings, the findings of fact set forth under points 1, 2, 3, and 4 in the proposed staff order as being found and concluded, and that also that the variance is approved based on that.
You said it better than I did, but we agree.
I mean, if that just...
Yeah. Yeah, what he said.
So the motion is to adopt the draft order as written.
And adopting the factual findings and the conclusions that are contained in that draft order.
Correct. Do we have a second?
And I will second that motion.
Okay. All in favor, say aye.
Aye.
All- Okay, adoption carries. Good. Okay. I think,
Last try was a charm.
okay, I think we need to adopt the minutes or anything.
I move that the minutes from the November meeting be accepted as presented.
And I will second that motion.
Okay, and all in favor, say aye.
Aye.
Okay, if that's, I don't believe there's any other business for today. If that's it, then do we have a motion to adjourn?
What was that guy's name?
So move.
What was the guy's name?
Second.
Bob, what?
All in favor, say aye.
Aye.